the threat of escape or evasion.
Okay, and if he attempted to escape, what should the officers have done?
Use reasonable force to prevent the escape.
And they do that when they were trying to stop him from escaping?
Are you asking me
Yes.
in this case? No.
They didn't. And
At an early point, I would say yes, although we didn't talk about that. But at the point of using deadly force, no. As I testified, that was excessive and unreasonable,
Right.
inappropriate, and inconsistent with generally accepted police practices.
yes, but I was not talking about deadly force. I was talking about your first opinion in your report about using the taser. And your report seemed to reflect that because they would find him some other time or somebody else would get him, that they should not have tried to stop him. Is that what your report says?
It's not, no.
Okay. Well, let's go back. You started working as a police officer, what year, 2001?
Yes, sir.
Is that right? And you worked as a police officer for 4 years and 7 months after that? Is that right?
Something like that, full-time, an additional 6 months as a reservist. The plaque on my wall says 5 years, but I'd have to calculate the exact number of months.
All right, well, let's assume it's 5 years, and it doesn't matter.
Sure.
That was 15 years ago, I believe, right? About that?
Yes. I left
And
about...
have you worked as a patrol officer since 15 years ago?
No.
And during the time you were a patrol officer, and we did some history here, how many first of all, do you know what a critical incident is?
Yes.
A patrol officer. How many critical incidents did you have in the 5 years that you were a law enforcement officer?
Oh, I was involved in maybe a dozen.
Okay, name one. I'm talking about a critical incident where a gun was used.
Sure. So my first one was in field training. I was not the shooting officer. My field training officer.
Maybe you misunderstood me. I'm not talking field training. I'm talking out in the area, being a patrol officer and having a real life incident. Did you have any of those?
Your Honor, I hate to be the third person talking at a time, but could the court please remind Mr. Gray that only one person can talk at a time? We should let the witness.
Right, and if he could answer my question, Your Honor.
All right, okay. We may continue, but yet for the benefit of the court reporter, please remember not to talk over each other.
Okay.
All right.
So what I'm talking about is when real life, when you're out on a patrol alone and you have a critical incident situation, how many of those did you have?
I was involved in, although not the shooting officer, I was involved in perhaps a dozen or so.
Of an officer shooting?
Either an officer shooting, an officer potentially being shot at, a significant use of force that we would classify as a critical incident.
Were you ever the one that shot the gun?
No.
Were you ever the one that was shot at?
No.
Were you ever in a situation such as the one that you saw in this video, the chaotic incident of this sort?
Someone attempting to flee an arrest and traffic stop? Sure, a number of times.
Okay, well, did they have a bench warrant for a weapons violation?
I don't remember specifically. I know certainly there were people who fled who had outstanding warrants of different types.
Well, I'm talking about an incident. Did you ever chase somebody that had a weapons warrant?
I'm sorry, that had a weapons.
Well, okay. I'm talking about a critical incident where you were involved yourself personally, and a man broke away from you, didn't want to be handcuffed, and either drove off or ran off. Did you have any incidents like that?
I had a number of incidents where people who did not want to be arrested either drove off or ran off. they did not result in an officer-involved shooting, if that's what you're asking.
Okay, so the person that drove off, if you can remember one specifically, did you have a person that drove off or that fought the handcuffs and jumped in the vehicle? That person had a warrant for a weapons violation, had a no driver's license, no insurance, and a temporary restraining order against him against the female, and the officers did not know who the female was in the vehicle. Did you ever have an incident like that?
I can't say that I had that particular collection of facts as an officer, no.
Did your heart ever race, and did you ever get real excited when somebody left your custody and ran off?
Of course.
Okay. So you're aware that's what happens. Your adrenaline starts pumping. And is that right? Did you ever get real excited?
Yeah, colloquially, sure.
Okay. And you had that police officers patrol for about 5 years, give or take. And during the 5 years, you never was a trainer. You were a trainee except in computer training, correct?
I taught report writing to officers, the policies that we used. I got a number of different training.
You answered the question. You just answer my question, okay?
I'm sorry, I guess I don't understand your question.
I guess you don't. Okay, so during the time you were a police officer, you never was a trainer for use of force, for shooting a gun, or any kind of conflict with a citizen, correct? You weren't a trainer.
No, I earned a number of instructor certifications, including several in use of force disciplines.
You were a trainer for the officers back there in 2001, 2005. You trained other officers on the use of force. Are you testifying to that today?
No, I'm testifying that I earned several instructor certifications.
Did you hear my question? Did you ever train any officers back there when you were a patrol officer? Did you ever train any officers on use of force at the police department you were in?
At the police department, no, I was not what we consider to be a defensive tactics instructor.
And you were actually a trainee, correct?
At the beginning of my career, sure.
And as far as, do you remember what a spear drill is?
A spear, as in Tony Blauer's spear system?
I don't know, but in your records you didn't choose to participate in a spear drill. You remember that?
No, I don't. If that's the spear system drill, no,
Do you remember not participating in it?
I remember.
I can refresh your memory if you want.
Sure. I remember at one point getting a fever in the middle of defensive tactics training and getting pulled out.
Thank you.
And I'm going to object, Your Honor, on relevance grounds.
The objection is overruled.
Read it yourself.
Sure.
Sure what?
I've read it.
Okay. And what was it?
I think the reason these guys are having communication issues is because that witness just said that they should have let him go instead of having this incident happen. And so now they're kind of having a disagreement, and that's why you're seeing the defense kind of outline everything the witness says to paint the picture.
Wouldn't participate in the spear drill then?
No, not particularly.
Remember? It did happen though, didn't it?
I don't know. I don't remember.
Okay. Too long ago? Is that right? Is it too long ago to remember?
Perhaps some combination of too long ago and simply not memorable.
Then you probably don't remember a lot of things that you did as a patrol officer, is that right?
Oh, I'm sure there are all kinds of things that I've forgotten.
15 years ago?
Sure.
And when you were approached to work in this case, you signed a contract, correct?
Yes.
And the contract calls for, what was the hourly rate?
I believe it was $2.90 an hour with 10 hours on days of expected testimony.
Okay, and up till now, you've billed them about $10,000, would that be fair?
Something in that range, about 35 hours worth.
And since November, let's strike that, the cap on your contract is $50,000, correct?
I don't remember.
Oh, I'll show it to you.
You may approach.
Yeah, thank you. I'm sorry. Actually, totally, I believe it might be 95,000. Take a read on that paragraph and see what you can figure out.
Oh, I'm sorry, I've misstated my rate. It's $2.95, not $2.90.
What else does that say?
It says quite a bit. What are you referring to?
The cap. How much is the cap?
The cap, I suppose if that's the total obligation clause, it will not exceed $95,000.
Thank you.
Yes. Mr. Gray, did you remember to ask your questions at the podium for the benefit of the court reporter?
Now,
Was that spiritual late June?
I'm sorry, I didn't ask you a question. The stop on this case last April 11th, you looked at that, that was illegal, wasn't it?
The traffic stop itself? Yes.
And the arrest was legal, correct?
Yes, officers had probable cause to arrest for the bench warrant.
Well, besides the bench warrant, you knew that Wright did not have a license, correct? You learned that from this case, did you not?
Yes.
You learned that he didn't have car insurance, correct?
Yes, that's correct.
And you learned that the registration of the tabs on the car were old, outdated. You learned-
Expired, yes.
Yes. And you learned that there was a lady in the car also, and when they pulled up his record, he had a temporary restraining order in order for protection for some lady, correct?
Yes.
And the officers did not know at that time who the lady was in the car, correct?
Yes, that's correct.
And then when they went up to arrest Mr. Wright, they had a special awareness, did they not, based on what you read, about a firearm being in that car, correct?
No, there were no specific and articulable facts that there was a firearm in the car.
Okay. But you as a patrol officer 15 years now, from 15 years ago, you would agree with me that there are many more weapons and firearms and cars and on person than there were 15 years ago. Do you agree with that?
I don't think there's any valid statistical evidence to support
Okay.
that.
And you as a patrol officer, now, 15 years later, it would not bother you a bit about a weapon and being in that car or being on his person, knowing that he had a weapons warrant against him. That wouldn't raise your suspicions or concern at all when you went back up to that car. Is that right?
That's not my testimony.
Well, would it raise your concern when you went back up to the car to arrest Mr. Wright that he had a weapons warrant outstanding, a bench warrant? He didn't show up, a judge ordered it. Would that raise your concerns about a weapon being in the car?
There is
That
always...
calls for a yes or no, by the way. Yes, it would raise my concerns, or no, it wouldn't.
I can't fairly answer the question with a yes or no.
Okay, well then don't answer it. So you can't answer that question because you don't know?
No, sir. I can't fairly answer the question with a yes or no.
All right. And the arrest of Mr. Wright at the car, when they got him out of the car, they said, "You're under arrest." All three said it, correct?
I know at least two of them said it.
Two said it, and Officer Lucky was trying to handcuff him, correct?
Yes.
And before Mr. Wright broke away from Officer Lucky, everything was according to protocol. They did everything correct, the officers. Am I right on that?
I would not describe it as the best tactical approach, no.
Okay. But there wasn't any unreasonable force involved, was there?
No, not at that point.
And you wouldn't describe it that way, but you haven't been a police officer for 15 years, have you?
That's about correct, yes.
Yes. So the arrest, the handcuffing of him was legal, correct? The attempt to handcuff him?
Yes.
Okay. And Wright's break away from that handcuffing, trying to get back in his car and actually getting back in it, that would be illegal, correct?
Yes.
Objection, Your Honor, calls for a legal conclusion.
The objection is overruled. The answer will stand.
And only as a result of what Mr. Wright did by doing that was what happened, and was chaos after that, correct? Would you agree chaos as far as the video that you saw?
I don't think it was only because of that, but certainly that was a predicate factor.
Well, Mr. Wright, he's the one that started it, correct? Nothing would have happened except for the fact that he broke away once he learned there was a warrant. Is that a fair statement?
Sure.
Okay. And do you agree that the video of the incident showed chaos? That it was very fast acting? I think it lasted, I can't remember here. Let's see, 5:19. About 30 seconds total from when he got out of the car. Is that correct?
Objection, Your Honor, has been asked and answered.
The objection is overruled. You may answer.
So, do you remember that? Or I'll ask you specifically. When Wright stepped out of the vehicle, it was 5 seconds between that time and the time he was told he was under arrest. Do you remember that?
That sounds about right.
And once he was told under arrest, 14 seconds later, and you remember in the video, that's when Officer Lucky was attempting to handcuff him. 14 seconds later, Wright pulled away and gets back in the driver's seat. Is that accurate about?
That sounds about right, yes.
And then 3 seconds after that, and if he tried to get back in the driver's seat, was trying to, 3 seconds after that, if you remember the video, Ms. Potter went around to the left side and said, "I'll tase you." Remember that?
Yes.
And let me ask you a question. When somebody says, "I'll tase you," that's a warning to the person being arrested to stop or you'll get tased. Is that a fair statement?
Yes, the purpose of the warning is to generate compliance.
Yes. And in addition to that, when two officers, Johnson and Lucky, are wrestling with the guy, that's telling Mr. Wright that, hey, we don't want you to leave, we want you to be arrested. Is that a fair statement?
Yes, I think it would have been abundantly clear to someone in Mr. Wright's position that the officers were attempting to arrest him.
And would that raise your suspicion at all as to why in the world would this man, Mr. Wright, attempt to get away from 3 law enforcement officers?
As to the reasons for it?
Yes, besides the warrant.
Objection, speculation.
He's the expert, Judge.
The objection is overruled. You may answer.
Would that go in your mind at all that this guy with 3 officers there, the one officer say, "I'll tase you," the other officer, Lucky, at first is wrestling with him and he doesn't stop? Would that cause you to be concerned that maybe he's wanted for something else?
Not unless
Wouldn't that be good
warrant
police
would...
work? I'm sorry.
Without the warrant showing up on a system, I would not be concerned that he was wanted for something else, no.
that wouldn't concern you, that a young guy is trying to get away from two officers, at least one, Officer Lucky, who you might remember if you saw the video, is a rather tall fellow, and Officer Potter are trying to stop him. He's wrestling with them, and Potter is saying, "I'll tase you." And nothing would enter your mind, I suppose because you haven't been a police officer in 15 years,
Objection, Your
but
Honor.
would it enter your mind at all? Pardon?
Mr. Gray, if an objection is made, can you stop talking, please,
I'm
so I
sorry.
can rule on it? All right. The objection is overruled.
Thank you. So you've heard my description, and you're the use of force expert, the police procedure expert, correct?
Yes.
And would that raise any suspicion in your mind that maybe this kid's got some other issues? No?
The question you had asked originally was, would it raise a suspicion that he was wanted on something else? And without another outstanding warrant for him to be wanted on would appear in the system, the answer is no. Would it raise some speculative risk that there might be other things going on? Without specific and articulable facts, you have at best a risk. You have some speculation of possibility, but you don't have the sufficient basis for legal action. There's no threat, if you will.
I understand that, but it also causes the officers to have that suspicion. We got to stop this fellow. Maybe there's something else there that we don't know about. Another investigation, not a warrant, but he's being investigated for another serious felony.
Your Honor, I object. Can we be heard, please?
I'm going to sustain the objection, and the jury is to disregard that last question, and you are not permitted to answer.
Now, when you wrote your report, you assumed that Officer Johnson was not in the car at the time of the gunshot, correct?
I would say I concluded that rather than assumed it.
Okay, and you concluded it because you said that you couldn't see him in the car?
That on synchronized versions of the video, it was pretty clear that he was no longer in the car at the time of the gunshot.
Okay, so the car, the reason he got out of the car was because when Miss Potter said taser, 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 that would be a warning to the other two officers to release him, correct?
I can't speculate as to his motivation, but it's possible.
Well, is that the signal? If you're the taser man here, the expert, isn't that the signal? Taser, 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 to tell the officers to back off? We're going to shoot this electricity at them?
The warning of tasers has a couple of meanings, a couple of purposes.
Well, one of the
which-
purposes is taser, taser, taser tells the officers to get away from him because I'm going to tase him, correct?
I would say it tells officers to remove themselves from the taser target area.
Okay.
To
And,
Your Honor, again, could the court please instruct?
well, Your Honor, if you would answer the questions yes or no, which I'm asking him like that, instead of giving me a statement afterwards, I would appreciate that he be instructed not to do that.
Still, again, one person at a time, okay?
All
You're
right.
going to have a really messy record if you don't comply with it.
Judge, I can't hear a word you're saying.
I said one person talking at a time, okay? So don't talk over him, and wait until the question's finished before you answer.
Yes, Your Honor.
All right.
Thank you, Judge.
Yes.
Okay, so after Wright's told he's under arrest, my watching and reading of the reports and watching the video, 14 seconds later, Wright pulls away and gets back in the driver's side. Do you agree with that?
I apologize. Did you want me to answer the previous question about the taser, taser, taser?
I thought you did. I thought you agreed that it was a warning to the other officers to back off. You didn't say that?
No, not exactly.
Okay, well, what did you say? Go ahead.
It's a warning for officers to remove themselves from the target area. Officers are trained to apprehend someone who's under the influence of a taser. You can grab, for example, someone's arms even while they're being tased in the torso. So it's not a warning to absent themselves and move 5 feet away or something like that. It is a warning that the taser is going to be used. The other significant reason for that taser warning is so that officers don't confuse the pop of the compressed nitrogen for gunfire, so they don't mistake the taser discharge for gunfire.
Okay. And one of the reasons is that to back off the individual, if they've got their arms on him when he's tased, to take their hands off of him because they might get a shock too, correct? Is that one of the reasons?
No, I would not say to take their hands off of someone, because you often want to apprehend someone while they're being tased.
Okay.
So it's to warn them that a taser is about to be used. If their hands are on someone's torso, which is the typical target area, you certainly don't want to be in that area of effect, but it's not to back off of them entirely, no.
All right. 3 seconds after Potter says, "I'll tase you," Kimberly Potter, first 5 seconds, Wright pulls away and Potter says, "I'll tase you," after 5 seconds. Now, on the video, after she said that at 2:01:55, did you see Mr. Wright at all say, "I give up," or "I won't fight anymore," or anything of that nature?
No, he was never compliant.
And that would be a warning that she was going to tase him, correct? If he didn't stop.
Her statement, "I'll tase you," is certainly a warning of an impending taser discharge, yes.
And if he would have stopped, you're assuming that the police officer wouldn't have tased him, correct?
Yes, that is a fair assumption.
And then at 3 seconds later, Mr. Wright, according to the video, is still fighting with the officers, and Potter says again, "I'll tase you." And did that affect Mr. Wright at all? Did he stop fighting at all when Miss Potter said for the second time, "I'll tase you"?
No, he was never fully compliant.
He wasn't
after
compliant at
pulling-
all, was he? What do you mean fully compliant? He was fighting, wasn't he?
After pulling away from Officer Lucky, he was never compliant.
Before that? Okay. I
Before
see.
that, he was compliant. Yes,
Yeah.
he was not fully compliant throughout the
Well,
interaction. He was not compliant after the pulling away.
I'm asking you about during the time he wasn't compliant, sir. Can you understand that? You know what I'm talking about?
He was, I think so. He was not compliant in the time where he was not compliant.
And the warning, "I'll tase you," the second warning, for 4 seconds he continued to fight with the officers, and the taser was pointed at him, according to the video, correct?
No,
No?
no taser was pointed at him.
You're right. The gun was pointed at him.
Yes.
Thank you. And by the way, the new taser, the 7, did you know that that taser and the one that Miss Potter got a month before, a month before this, she got the new taser, Taser 7. Prior to that, she had a different taser. And the different taser had a yellow handle and a yellow top, where the new taser, the 7, had a black handle and a black top. Did you know that?
I believe there was...
Did you know that? That calls for a yes or no.
I
Answer the question, yes or no, please.
don't think that's an accurate description of the taser.
The taser that she had?
The X7.
I'm talking about, okay, the Taser 7, the top was black and the handle was black, correct? The rest of it was yellow. Fair statement?
There was... can you clarify what you mean by the top of the
Well,
taser?
where you got your handle here, and right here was black from where the handle is over here.
Yeah, there's yellow on the sides of the part that protrudes from the thumb side of the hand in a grip, yes.
Yes, but the handle is black and the top is black, correct?
I believe that's correct.
And, well, you're the taser expert, wouldn't you know that?
There are a number of different models of tasers still in use.
Did you know that the taser that she had before this, 3 weeks before this, was all yellow? Did you know that?
That was the X26P, as I recall, and I believe the model, I don't remember the coloration of the model she had.
Okay, so you didn't know that. That's your answer, right?
I don't recall offhand. I can see if it's in my report if you'd like.
You also had in your report that Potter was not aware of Johnson being in the car. You remember that, writing that in the report?
That's a slightly inaccurate description of my report.
Well, you said that you couldn't. Well, what did you say?
I said the available evidence indicates that she was not aware of that.
Okay, and now the available evidence is that he was in the car, he testified he was in the car, and he was fighting with Mr. Wright before the shot. Did you read that testimony, or did you hear about it?
I heard the testimony, and that is consistent with the body camera video. He was in the car and struggling with Mr. Wright prior to the gunshot.
Okay, and it was a second prior to the gunshot, correct? The taser, and then the Potter fires a gun? 1 second or less.
Between
taser, and the gun being fired.
yes, by the end of that warning, it was a relatively short period of time, within a
The answer
second.
is yes. Would you answer my questions if you can with a yes or no? It'd be a lot easier.
Well, taser takes some time to say. By the time of the end of that warning, I agree, it was less than a second before the gunshot.
And that's when the officers took their hands off him, correct?
I'm sorry? No, the officers had their hands on him well before the gunshot.
Yes, but when did they take their hands off him? It was before the gunshot, wasn't it?
Sergeant Johnson took his hands off of Mr. Wright and backed out of the vehicle prior to the gunshot. Officer Lucky had hands at least in the direction of Mr. Wright. I don't remember offhand if they were making contact at the time of the gunshot.
Okay.
It was immediately after the gunshot that Officer Lucky backed away.
Is your testimony that Mr. Johnson's part of his body was not still in the car?
I testified earlier that his hands were still in the car. He had backed his torso out of the vehicle. His hands were still in contact with either the passenger or perhaps Mr. Wright's right hand.
So he was in the passenger's doorway, and he's leaning over with his hands on Mr. Wright. Is that what you're saying?
No, I'm saying he was backed out of the open front passenger door. His hands were either on the passenger or on Mr. Wright's right hand that was in front of the passenger.
Okay. Oh, that's what I thought he said. That's all right.
Members of the jury, I think we're overdue for a break, so we're going to take our afternoon break right now, and it'll be 20 minutes, okay?
The judge is not happy. She's got her hands on her hips.
Sorry. Okay, counsel, we're taking a break.
Thought maybe she was gonna scold them. She was getting ready to do the Macarena. I don't think that's quite what she was gonna do. One judge, one cup. Yes, good one. All right, everyone. So I did get rid of my Trailblazer. That happened. That was a thing. Got the battery out. Whatever. It is what it is. Problem solved. But then my Instagram got stolen. And so now there is somebody in control of my damn Instagram trying to use Cash App scams to get money off people that are subscribed to me and stuff, or following me on Instagram. So that's real cool. So I did everything I could to try and get my account back. None of that stuff worked. I talked to Facebook customer service, and they said they're going to try and do something and let me know in the next 48 hours. We'll see. So yeah, my day's going pretty rough. I don't know if it was, I mean, it's a good thing, but I was dealing with it, and then I had like 30 or 40 people show up like, hey, did you know your Instagram is stolen? And I'm like, yes, I totally know. What's interesting is how it happened. Oh, hold up. All right. So, while I was live, I received a message from my sister saying, hey. And I'm like, hey, what's up? And they're like, I need help getting back into my Facebook account. And I didn't think nothing of it. I'm the smartest person I know when it comes to technology, and lots of people come to me to ask me for help in these kind of things. And I was like, yeah, I can help you. And they're like, okay. They're like, I'm just having trouble signing into my account. And I was like, all right, well, call my phone. And sent my phone number. And then all of a sudden I signed out of my account, signed me out. And I tried to sign myself back in, and it said the account didn't exist. And then I knew they got me. Something happened. What happened was they had hijacked my sister's account, and then must have looked through our conversation and realized we were siblings, because we don't have the same last name or anything like that. And yeah, nailed me. Got me good. I hope their family dies of COVID. Anyways. We'll see what happens. If Facebook doesn't get my account back in the next 48 hours, we're going to do a mass reporting, and we're all going to report the shit out of that account until they delete it. Because I can't have people with my name and my face trying to scam my followers and send emails, and God only knows what else they're doing. Yeah, so that's a thing. We'll see how it goes. Just monitor the situation. I don't know what else to do. Their help center sucks. I'm glad I'm not like more famous or popular than I am, because they just jacked my stuff, and then I was trying to find help. There ain't nothing. There's no help. It's like, you're on your own, buddy. They got a book of a page that you can read that basically tells you there ain't no hope for you. Like, I received 30 something emails saying that my email had been changed, my name had been changed, my phone number been changed, everything. All my private information had been changed on my account. And it says right on there, you know, if you didn't change your email address, click here to like revert the effects. But when you click it, it just says there's no information to be found. Like, that stuff doesn't work. If their fake security measures were actually real, I would be straight. But because it's not an actual functioning system, there's nothing I can do about it. We'll see how it goes. But at least the scrapyard called me and told me that they were going to give me $600 for my Trailblazer that they came and picked up. It was a total giant piece of shit. So at least there's that. I mean, it wasn't all bad today, and we're live, and I don't think we're buffering. YouTube is buffering me. I'm just gonna off myself right here. No, I'm kidding. Don't do it. Don't do it. Kill me. Kill me with that stuff. Hydrodynamic. I get emails like that all the time. I wonder if this person is watching. I get fake emails every single day from an email that ends in .cz, and they are offering to do some sort of collaboration with me where I will promote their stuff on the live and they will financially reimburse me somehow or some other way. And they write me every single day. And yesterday they told me they were a representative from ASUS, like ASUS motherboards for computers. And they've told me that they're from video games and they're from all kinds of stuff. Hey, I'm a representative from this, that, and the other, and we want to work with you and all this stuff. And it's BS. It's all fake. It's weird. These scammers be after me. It's weird. I see that, man. I don't know why my mic is so quiet. I did that yesterday too. I wonder if I don't know why that's happening. Weird. I do not know. I have no idea why that's happening. I see the signal's low, but I don't know why. I think it's a software issue. Hopefully I don't blow your eardrums out. Alright, that's probably loud enough now, but then tomorrow when I go live, it'll be rough. Chris, I think if a 3-letter agency was to hire somebody, I think what they do is they show up and try and take you out, and if you survive it, you get the job. I'm convinced. That's how it goes. It's like the Matrix or something. Yeah, I'm sure the mic level is fine now, but tomorrow I'll be blowing your eardrums out. I think it's the software. I don't think it's actually my equipment. Thank you so much, Secret DeVos, for your donation and your support. I really appreciate you. Thank you for being here. We should think of a poll to do whenever they come back. Time goes by slowly watching it. You guys watching the clock? Not me. I don't know. I don't know why they're beating this case to death. I feel like we have plenty of information at this point. There's no reason to keep bringing in witnesses to say a whole bunch of nothing. Bipolar Bear, I don't think there's a way she could get not guilty. I mean, maybe, but she made a mistake. It resulted in death. Maybe if she didn't admit to it being a mistake, she would have a chance. But the fact that she says it was an accident, I didn't mean to do it, means that she was not in control of her pew, and it resulted in death. And that is that. So I don't know why they keep bringing out all these people in. They need to make a decision. How much time is she going to do? Like, I really don't think she's going to walk. Chris, your neighbors can hear me? Are they fapping to me right now? They might be. You never know. What kind of neighbors you got? You got those weird neighbors? My neighbors are all broken on Section 8. It's unfortunate. Yeah, Diane, there's not a bunch of interesting people on the stand because they're all cops. It's all cops. I wonder how many cops they've interviewed so far. It's been quite a few, 6 or 7 of them so far. Debacles, you think that the witness is from the Chauvin trial? I don't really know. I just remember Fish Choker. And like the EMT person and the gas station clerk. I don't really remember anyone else. You think the taser specialist is paid off? Debacles? Maybe we'll do the poll on that when they come back. By the time they come back, I think they're going to wrap up this witness and then they'll call it a day. I wish they would say how many witnesses they had left. They're going to just stretch this out. That's what she said. Neon Love Machine, you think she's going to get 6 months? She might. There we go. Make sure you guys take a second to hit that like button. The more likes that we get in a short period of time, the more people the algorithm will bring into the chat to come hang out with us and see what's going on. So please hit that like button. Bipolar Bear, the judge has the runs. She might. I don't know. She's spicy today. She's not tolerating the nonsense. And the attorney was just railroading the witness. He wouldn't even let him speak, but the witness also wasn't really being cooperative. You know, God forbid that he said yes or no to anything. Everything had to have a detailed explanation. Couldn't, I don't know. Uncooperative. Destiny Gal, you think the jury's going to go on forever because people are getting pissed about the lifelong criminals portrayed as victims? It could be. I mean, that area might like it though. Some of these places are all about that. You know, like the guy just said, he felt that it would have been safer protocol to let the person escape and drive away and go pick him up from his house than to have that kind of interaction, and it resulted in his death and a car accident. So I don't know. I mean, it's kind of what that city prefers by its leaders. What's up, Jay Wright? Geez, hydrodynamic, that's an expensive grocery trip. Yeah, I appreciate you being here, Uncle Ruckus. Bipolar Bear, are you talking about the Russia collusion? You bringing Trump into this? This was Trump's fault, didn't you know? Trump's the one that shot Dante Wright. This is Trump's fault. And Joe, you think she'll be guilty because the city is afraid of Kyle? Like, I don't know. Kyle might show up and clear this out. I don't know. He's busy doing interviews and stuff now.
All right, counsel, I am going to tell you again. Only one person can talk at a time. And Mr. Gray, you've got to let him finish his answer before you start interrupting him.
Can you instruct him if the answer calls for yes or no to say yes or no?
You know, I'm not going to tell him to say yes or no if he can't answer with a yes or a no. But I think we got it. Our poor court reporter has a really hard job, and let's not make it harder for her. Okay? All right, you ready for the... Thank you. You can have a seat. All right, thanks, Deputy.
Why are you guys all talking about Binger's Dinger? What is wrong with you guys? A bunch of hooligans. I always got a bunch of hooligans in my chat. Goodness.
Okay, please be seated. Mr. Gray, you may continue.
Thank you.
Okay, please be seated.
Thank you, Ron. Mr. Stoughton, I'm going to ask you a couple of questions about your CV, your curriculum vitae, and you have one on page 6. You have it titled Selected Expert Consulting Reports, Depositions, and Trials. And most of the listed selected expert consulting matters are civil. Is that a fair statement?
Yes.
And these civil cases that you are a consultant on, or sometimes testify and sometimes give a deposition, the civil cases are 1983 actions, correct? Most of them?
1983 or state tort suits, yes, or a combination of the two.
Okay, and a 1983 action is an action where a law enforcement officer, or maybe the city that he works for also, are sued for unreasonable force. Fair statement?
Some of them are alleged excessive force cases. Some of them are other Fourth Amendment violations like unlawful search, unlawful arrest. Some of them are, it's a range, but they are allegations of constitutional violations generally.
And what happens in those cases is an individual, a plaintiff, sues the police officer and maybe the city under Bivens versus United States, correct?
Not under Bivens. Bivens is a federal action, so it would be under Monell.
Okay, but the federal actions would be under Bivens.
A lawsuit against a federal agent or federal officer would be a Bivens action. A 1983 suit is against a state or local officer.
All right, I'm not going to take issue with you on that. The fact is that you've assisted on, I counted here about 30 cases involving plaintiffs suing law enforcement officers. Is that about accurate?
It's.
On the CV?
I'm sorry. Are you asking me whether it's accurate on the CV or accurate as to what I've
The
done?
CV that I received, I'm asking you.
Yeah, that sounds about right as far as listings on the CV. Sure.
And it is true, is it not, that of these 30 cases you cite, I counted 27, but take my miscount off and call it 25. That of the 30, 25 of those were either you testifying as an expert for the plaintiff, which would be the person suing the cops or the city, or taking a deposition or assisting the plaintiff in suing law enforcement. Fair statement?
I would not describe that what I'm doing is assisting the plaintiff. I am reviewing a case file and rendering an opinion.
And you're doing that for the plaintiff, right?
I am hired by plaintiff's counsel to review the case and render an opinion.
And once you render that opinion, if you believe that there's a violation of the individual's constitutional rights, you tell the lawyer, right?
So my opinions in those cases still apply the professional standard. I'm not testifying that there was a Fourth Amendment violation in most cases. What I'm saying is an officer's actions are or are not consistent with generally accepted practices.
And you're hired by the plaintiff in 27 of those 30. Is that right?
The CV has maybe half of my total retentions. So of the ones on my CV, I would have to count them up. I haven't done so, but that could be right.
Would you say that you're hired by the plaintiff in more cases than are in here, in this CV?
Numerically or proportionally?
By the number, are there more than 27?
Yes.
Okay. You also have written about police body-worn cameras. Actually, you wrote a North Carolina law review, and I believe it was in 2018, about body-worn cameras, correct?
Yes.
And I quote you in this body-worn camera article, Limits of Human Interpretation, page 1405.
The objection,
Regards improper form of cross-examination.
the objection is overruled.
You write in the law review, the potential for body-worn cameras to have informational benefits assumes that viewers will be able to accurately interpret the recorded videos, but just as digital cameras have inherent limitations, so too do their users. We all suffer from a range of cognitive limitations that can affect our ability to interpret evidence, including video footage. Is that what you wrote?
I don't recall the exact wording, but it certainly sounds like what I wrote.
Would you take issue? I can show it to you.
No, I accept it. It is definitely the point that I was making, and I will accept your representation that that is accurate.
Then on
The
the
wording
next
I used.
page, you write, one such cognitive bias is motivated reasoning, defined as a tendency of people to conform their assessments of information to some goal or end other than accuracy. Did you write that?
Same point, yes, or at least certainly words to that effect, and I accept your representation that that's what I wrote.
Relatedly, the tendency to interpret information in a way that confirms one's pre-existing worldview or beliefs that Cahan calls identity affirmation or identity protective cognition also affects the way we see the world. Did you write that?
Yes, Kahan, yes.
So what you're saying here is that the body-worn camera's informational benefits assumes that viewers will be able to accurately interpret the recorded videos. But just as digital cameras have inherent limitations, so do their users, correct?
Yes, absolutely. A great deal of the body-worn camera training that I do is on interpreting body-worn camera footage for exactly those reasons.
And what you did in this case is interpret body-worn cameras, correct?
I would say I interpreted body-worn camera footage in the compilation of an entire set of evidence. Certainly,
Okay.
body-worn camera footage is included in the body of evidence, but it's not.
You interpreted body-worn cameras, and you also read the police reports in this case?
Police reports, about 6,000 or so pages of documentation, interviews, dash cam or squad cam footage, yes.
And you also, did you know about Sergeant Johnson's testimony in this case?
Yes, I also reviewed some of the testimony in the case, including most of Sergeant Johnson's.
And the opinions you wrote were prior to Sergeant Johnson's testimony. Fair statement?
Oh, absolutely. Yes, I wrote the report prior to his testimony.
Thank you, sir.
Thank you.
Mr. Green?
Thank you, Your Honor. Professor Stoughton, I think I'll be brief. You were asked about this article you wrote in 2018 about body-worn cameras. You recall that testimony?
Yes.
And
Excuse me.
And during direct examination, I asked you about some of your work with body-worn cameras. You talked a little bit about that. Was that paper you wrote part of your answer, what you were telling us that you have done with regard to body-worn cameras?
Yes, that's part of the body of work. I focused on body-worn camera footage and its interpretation.
And Mr. Gray read to you a couple of quotes from your article about the potential for body-worn cameras to have benefits and limitations.
Yes, that's correct.
That was, I think, the essence of the first part he read.
Yes, the idea that that getting the most information out of body-worn cameras is limited by the first clause. There was some of the limitations of the technology itself, which I talk about in a previous section of the article, and then that section is about human interpretation of camera footage.
And the second part that he read to you was about, my understanding, some kind of cognitive bias, correct?
Yes, a particular type of cognitive bias that affects human ability to interpret information.
And so you are aware of that, have studied that?
Yes.
Did you, well, when you were creating your opinions in this case, were you careful to avoid any cognitive biases regarding the body-worn camera video?
To the maximum extent possible, absolutely.
You were asked about the different versions of the taser from the X26P to the Taser 7. Do you recall that being asked about that?
I do, yes.
Your Honor, may I approach to retrieve Exhibit 203?
Yes, you do.
And Professor Stoughton, I will represent to you that Exhibit 203 has been previously received in evidence as the taser that Ms. Potter wore on the day of this incident. And, Your Honor, if I may approach, I'd like to have the witness explain what he understands the difference in the coloring of the two models.
You may approach.
Thank you.
And I'd like to first, for the record and for everybody in the courtroom, the battery has been removed from that taser, correct?
It has, yes.
So it's incapable of firing?
Yes, and yes, that's correct.
So, and if you could just point out to the jury the differences in the two, just trying to remember to stay close enough to the microphone to be heard.
Sure. So the Taser X26P, as I recall, has two different coloration patterns. It has an all-black model, and there is, I believe, an all-yellow model where the entire top is yellow. This is the X7 where, except for this strip, the handle is black, and then the top of the taser is half yellow, half black. The sides, as you can see, are predominantly yellow, but for the release switches there.
And then I would like to show you Exhibit 13, and I would ask that it go, that's the body-worn camera of Ms. Potter, and ask you to go to 20156, please. And while Mr. Miller is doing that, Your Honor, may I approach the witness to retrieve the exhibit?
Yes, you may.
Do you see that portion of Exhibit 13 on the screen in front of you?
I do, yes.
And for the record, it does, the timestamp reflects 20156. Would the yellow markings on Exhibit 203, Officer Potter's taser, have been visible if it had been in Ms. Potter's hand rather than her Glock?
Yes, had the firearm been a taser, the yellow markings would have been very clearly distinguishable on this picture.
You were asked about the interaction between Mr. Wright and the officers, Lucky and Johnson, and the word I believe that Mr. Gray used was fighting. Do you recall him asking you those questions?
Yes.
Was there a time when Mr. Wright was compliant?
There was a time when Mr. Wright was compliant prior to pulling away from Officer Lucky's attempt to handcuff him, yes.
And then after that, did you see any evidence that Mr. Wright was assaulting the officers?
No, the evidence, both in the material I reviewed as well as the testimony, suggests he was not aggressive or assaultive in the sense of, for example, trying to strike the officers or retrieve a weapon or the like.
But he was trying to get away.
Yes.
So is the word fighting one that you would use to characterize Mr. Wright's behavior?
I can understand how that word would be used casually. It's not the word that I would use.
What word would you use?
You could use resisting, actively resisting, even struggling. Fighting, I think, for me at least, connotes a degree of aggression or assaultive behavior that is lacking in this case.
Mr. Gray asked you if you would agree that if Mr. Wright hadn't decided to be non-compliant and pull away from the officers, none of this would have happened. Do you recall that question?
I do.
When, based on your training and experience in this field, once an individual attempts to pull away from the officers, are the officers still required to use reasonable force?
They are. The idea that merely because someone resists an officer sort of allows officers to do anything at all is one of the points that we talk about in the book. Should be a two-staged question. First, did the individual resist in a way that justified some use of force? And then if so, how much, what type of force, how severe is the force that officers could use in that particular circumstances? So the fact that someone is resisting can certainly justify some force, but does not allow officers to use any amount of force in response.
And you were asked about your incidents when you were working as a police officer. Do you recall being questioned about that?
I do.
And you were asked if, when you got into incidents, whether your adrenaline started pumping.
Yes.
And I think you said that, colloquially or casually, one way of saying it?
Sure. Yes. Yes.
Based on your training and experience in the field that you currently work in, Professor Stoughton, when an officer gets into those situations and, to use the phrase, the adrenaline starts pumping, are they still required to use reasonable force?
Absolutely.
When you were working as a police officer, did you have to, when you started a shift or went to work, have to think about being able to act reasonably as a police officer?
Object, Your Honor, it's outside the scope of my cross-examination.
The objection is overruled. You may answer.
Yes. Prior to every shift that I worked, it was my habit, as I was putting on my vest, as I was strapping on my gun belt, to review my equipment to make sure that I was emotionally, I suppose we would say now, emotionally in a position to do my job.
That's all I have, Your Honor, and if I may approach the bench to return the exhibit.
Yes. Mr. Gray?
Yes, just a couple. Mr. Stoughton, you do agree with, on that video, you do agree that when Mr. Wright broke away from attempting to be handcuffed, that he tried to get into the car, got in the car, and if the officers had let him go, he would have taken off in that car. Is that right?
Yeah,
Speculation here.
I'll let the answer stand.
I think that's the logical conclusion of what he was trying to do, yes.
Yes. And if he had taken off in that car because the officers were there, not in their car, they were standing out in the street, you would logically conclude that he'd take off quite fast, correct?
I don't think there's enough information to say their low-speed flight is not uncommon in vehicles.
Usually when somebody takes off from 3 officers in 2 squad cars, you drive slowly.
I'd say it's not uncommon for someone to flee a traffic stop at low rates of speed or high rates of speed.
They're both the same. Is that what you're saying?
No, they're different rates of speed.
Okay. Well, so wouldn't it be reasonable for a person fleeing from the law enforcement officers, 3 of them, 2 squads, to leave in a fast manner?
I don't think it's particularly reasonable to flee from an arrest.
Would it be reasonable to flee if you're stoned on marijuana?
I-
He would,
The objection is overruled. You may answer.
you were aware, were you not, based on you knew the testimony here, that the autopsy witness said that he had a high rate of marijuana. Were you aware of that?
I am aware of that. It didn't factor into my analysis because it wasn't information available to the reasonable officer at the time.
But you would agree, would you not, that it would be a danger to the public to have somebody driving a vehicle high on marijuana? Fair statement.
Objection to relevance.
Yes, the objection is sustained.
Okay, sure. That's all I have. Thank you.
Mr. Frank, any redirect?
Nothing further, Your Honor. Thank you.
Okay. You may step down.
Thank you.
The state may call its next witness.
Thank you, Your Honor. The state calls Aubrey Wright.
Do we have a standing objection?
Yes. Okay, Mr. Wright, please come forward and stand behind the witness chair right next to me. And will you please raise your right hand? Do you swear under penalty of perjury that you will truthfully testify in connection with this trial? All right, you may take a seat. And could you please remove your mask? State your full name and spell it.
Aubrey Wright, Arbuey. Last name is Wright, Wright.
Okay, Mr. Wright, a couple things to keep in mind when you're testifying. The court reporter is taking down everything that's being said, so you have to answer orally instead of shaking your head. And please don't say uh-huh and uh-huh and because that doesn't come out on the record. Also, if you don't understand the question, please let the questioning lawyer know and it will be clarified. If an objection is made, you need to stop talking immediately and not answer the question unless I tell you to do so. All right?
Yes, ma'am.
And only one person can talk at a time because the court reporter can't take down two people talking at the same time. Wait until the question is finished before you start answering.
Okay.
All right. Counsel?
Thank you, Your Honor. Good afternoon, Mr. Wright.
Good afternoon.
I'm going to ask you some questions just about who you are and have you introduce yourself so the jury can learn a little bit about you, okay?
Okay.
How old are you, sir?
42.
And what city do you live in?
Minneapolis.
How far did you go in school?
12th grade.
And are you working now?
Currently not.
And are you married?
Yes.
Who are you married to?
Katie Wright.
And does Katie Wright also go by her legal name, Katie Bryant?
Yes.
Do you and Katie have any children together?
We have 3.
And could you tell the jury their names, please?
Dante Wright, Destiny Wright, and Diamond Wright.
And is Dante, your son Dante, is he no longer with us?
No.
Was Dante the oldest of the 3 children?
Yes, he was our firstborn.
What was Dante's role as the older brother to 2 younger girls?
His role to the younger girls was the big brother, to look after them, watch after them.
And what was his relationship like with his younger sisters growing up?
The relationship with the younger sisters was like a big brother. Joked a lot, always constantly following behind them, making sure they were okay.
And did you and your wife Katie and your children Dante and Diamond and Destiny all live together up until Dante's death?
Yes, we did.
Do you also have some other children from a previous relationship?
I do.
And how many other children do you have?
I have 2 other kids prior to our relationship, Marcus Wright and Monica Wright.
And where do Marcus and Monica live?
They live in North Carolina.
So between you and your wife, Katie, how many children do you have altogether?
Oh, she had 2 kids prior to our relationship, so we had 7 altogether.
So getting back to your life with Dante growing up and his younger sisters, what kinds of things did you and your family do together for fun to pass the time?
Well, we got together every Sunday we would have cookouts and stuff like that. Family days, I mean, we would do movies and stuff like that. We did a lot of things as a family, as a group, because we're like all we have, so.
Cookouts, you said?
Cookouts constantly every Sunday, every weekend, pretty much.
Did Dante have any favorite foods?
Well, yeah, he did. He liked chicken, I guess. We all did. So,
Was that a family favorite at the cookouts?
pizza. Excuse me?
Was chicken a family favorite at the cookouts?
Oh, yeah. Yes.
Did he like sports?
He loved basketball. He played pretty well. He's a left-hander, so he was pretty good.
And as he grew older, into his teenage years and beyond, did he have a variety of different jobs that he worked?
Had a lot of different jobs. I even got him a job with me before.
And when you say you got him a job, was there a time where you and Dante worked together?
Yeah, it was the time we worked together. I was his boss, and I was happy, to have my son coming on to work with me.
Where was it that you two were working together?
I was a manager at Famous Footwear.
And about how long did you two work together at Famous Footwear?
About a year. About a year. He worked there about a year with me.
About how long was that before he died that you two worked together?
Well, it was his last day was when the COVID hit. So his last day working with me was right in the beginning of the COVID.
So about a year ago is when you guys stopped working together. How was it for you working with your son, Dante?
It was great. It was challenging, to work with my son. I tried to let him understand the difference between where at work I'm your boss and at home I'm your dad. It's a difference. So, but it was funny. Like it was this one time where I had sent him home because he was on his phone at work and he wasn't supposed to be on the phone at work. I was like, yo, we gotta go home. And so he went and asked my boss, is it okay if my dad sends me home? And I'm like, my boss like, yeah, he's your boss. And I'm like, well, you need to go home and come out in the hallway. And he's still there. And I'm like, well, why are you still here? And he's like, well, Dad, I rode with you. I couldn't go home because you're my ride. I think it's funny, but yeah, that was a funny thing that happened at work.
So not only were you working together, but you were driving to and from work together?
Yeah, every day, yeah.
You got to spend some quality time together.
Yep, spend a lot of time together.
Your Honor, at this time I'd offer Exhibit 240.
Any objection to 240? Okay, I previously ruled on it over defense objection, and 240 will be admitted into evidence.
Thank you. If we could publish it, please, and put it on the screen. All right, there's a picture on the screen now. It's Exhibit 240. Could you just explain to the jury what's shown in this picture? Take a minute if you need one.
Picture of me and Dante. You see how, I was holding him. See how his arm, we had a close relationship. He was me and my wife's first child.
And was this picture at your home?
Yes.
Was this not long before he passed
This
away?
was right before he passed away.
And if we could put on the screen Exhibit 3, please. That's already been admitted. Did your son Dante also have a son of his own?
Yes.
And
First and only child. That's my grandson, Dante Jr.
And your grandson's name you said is Dante Jr.?
Yes.
How was it seeing your son Dante as a father?
Excuse me.
How was it to see your son as a father?
Man, to see him as a father, it was like I was so happy for him because he was so happy. He was so happy about Junior. And this was my chance to be a grandfather.
Did they have a close relationship?
Yes.
And did Dante Jr. spend a lot of time with your family as well?
Yeah. Dante Jr., Dante lived with us. Junior was pretty much there every day. And he loved his son.
And do you love your son Dante a lot as well?
A lot. I loved Dante. He was loved.
Do you miss him?
I miss him a lot every day.
Thank you, Your Honor. Nothing further.
Is there any cross? All right. Thank you, Mr. Wright. You may step down. Does the state have any further witnesses?
Well, I wonder if they're about to wrap this up. I'm running out of witnesses to tell stories. I don't know why Colonel Sanders always looks like he's ready to throw hands. He's got a lot of energy in him. Thanks for being here, Douglas. Enterprise, you're making a documentary on how my Instagram was stolen? Yeah, my documentary is gonna be awesome. I already know. It's gonna be awesome. Hopefully they get me my account back. Otherwise, we're gonna nuke it. The Mackumentary. Oh man, that's so good. That's such a good one. She's playing Call of Duty. What do you think her Call of Duty username is?
All right, members of the jury, we're going to stop right now, and I'm going to let you go home, but I want to remind you, and I've told you this before, I don't mean to insult you, but it's very, very important that you not listen to any news reports about this case. Don't read any articles. Don't, any podcasts. Don't do any research on the case. And stay off social media about this case, okay? Now, I heard that we might be having some bad weather tonight, and tomorrow the roads may be a little icy, so I do want to start on time tomorrow at 9 o'clock. So please take that into consideration, the fact that it might take you longer to get places tomorrow morning, okay? All right. Have a nice night, and we'll see you, and drive safely tomorrow morning, okay?
You guys are killing me with the Call of Duty names.
Okay. Council, does anyone want to put anything on the record right now?
Yes, Your Honor, there are a couple of issues we would like to raise.
Okay.
Your Honor, in the anticipation that the state is going to rest tomorrow, we have noticed that the defense is going to call some witnesses. The defense has provided a somewhat lengthy list of witnesses that I believe would be characterized as 404A1 witnesses or character witnesses. I got note of at least probably 12 witnesses. I just wanted to know, this is essentially a prospective motion to prohibit needless cumulative evidence of 404A character evidence. So far, we've heard from Johnson, who's elicited a character opinion, Flesland, who's issued a character opinion supportive of the officer, Sergeant Peterson, who's also been offered a character opinion. I, based on the discovery, anticipate that Colleen Fricke will share one, and then also former Chief Gannon. That would be 5 to date. That would be notwithstanding, I think, the 10 pending based on their witness order. The court has heard the needlessly cumulative objection raised by the defense, I guess repeatedly since the trial began, and the court has sustained some of those objections. Here, the shoe is on the other foot. At this time, the state is objecting to the defendant's apparent intention to present additional character evidence beyond that of Fricke and Gannon's. At some point, Your Honor, and we think it would be after Gannon's testimony, that would constitute the needless presentation of cumulative evidence. We're bringing this up prospectively now because, given the abundance of witnesses, I think that if the court properly guides the defense, they can have their choice as to who among them they would want to call if they chose to go a different direction. You have not seen and will not see the state attempt to contradict these opinions shared. Repeated testimony along the same lines illuminates nothing further, and it's an improper effort to bring a chorus on these issues where I think soloists have already done the job. At some point, such testimony has no probative value. It's duplicative, and the state's position obviously is, after Gannon testifies, 5 is enough. When we have addressed these issues of cumulative evidence so far, the state has referenced to State v. Amos. That would be at 347 Northwest 2nd, 498. That's a Minnesota Supreme Court case of 1984. Essentially, in that case, a party decided they wanted to parade a bunch of witnesses into court to testify that a particular location was notorious for drug dealing and gambling. The court allowed 3 witnesses to provide such testimony, but after that did exclude further testimony as being needlessly cumulative. Here we have the same point. We have heard from these witnesses. The state is not even objecting to the defense calling Fricke and Gannon for those purposes, but at that point it seems like the point has been made and that the court is certainly within its discretion to exclude further character evidence. There isn't perhaps a 404A1 case directly on point, Your Honor, but there is a case within the Spriegel realm. I referenced State v. Washington. That's 693 Northwest 2nd, 195 at page 203. In that case, the Supreme Court noted that it was proper to limit Spriegel evidence at a certain point to reduce the risk that juries will become fixed on it and will blur the lines between evaluating the elements of the offenses charged and simply the evidence of the defendant's character. I think that it's right for the court to consider that, and I do believe that it's timely, although a bit prospective for the court, for the state to raise that motion at this time. That's the state's first motion with regard to this. I believe the state has two other 404A1 motions. We could hear this first, or I could give it to you all now. Which would you prefer?
Okay, I would like the defense to respond at the podium. Mr. Ng, how many character witnesses are you intending on
Well,
calling?
we're not going to call 12. We had 5 scheduled for tomorrow. Sam Smith, Lisa Thies, Ann Curtis, Frank Roth, and Tom Hall. We were going to evaluate when they got in how many we were going to use. I'm somewhat sensitive to their claim, although I'm somewhat insensitive to the idea that the state has been efficient in their presentation. I find their presentation to be entirely redundant, and so the claim here that we can't spend 15 minutes on some testimony doesn't resonate with the defense.
Well, it's good to hear that you're not going to be calling 12.
No, of course
Okay.
not. And, you know, the police officers were fact witnesses. They happen to
I'm
know
talking pure character witnesses.
For pure character witnesses,
Okay.
we have 5. I may not call all 5. Those are the pure ones. That's the only reason they're here.
Okay. Are they all 5 of them going to say the same thing?
Well, I'm constrained by your ruling as to peacefulness and law-abidingness. Yes, you know, I know her. We met her. I've known her since childhood. I've known her for 5 years, 10 years. You know, that sort of
Okay,
thing.
pick 3.
Pick 3. We will do.
All right. Okay, anything else? Oh, I think you had another motion. Okay.
I would note, Your Honor, depending on which 3 the defense calls, we may have no discovery from any summaries of any statements made, so I wouldn't make any demands of any statements made by those witnesses, respectfully. At this time, this, I guess, motion pertains strictly to Officer Fricky and Tim Gannon, who are apparently prepared to provide character opinions. So I don't know whether they are included in this group of 3
They
that the
are
court
not
talked
included.
about. Because Tim Gannon is not a fact witness, Your Honor. But at this time, the state moves to limit the opinions of Officer Fricky and Tim Gannon to those specifically permitted by the court. And I know that we just went over, Mr. Ng went over what he believes the court's ruling was with regard to what pertinent traits are relevant in this case. That would be law-abidingness and peacefulness. In the defense interview with Officer Fricky, though, additional opinions were laid out that I think are beyond the scope of the court's ruling, and I'll just list things such as patient with suspects, unfailingly polite, treated everyone with respect, devoted to victims of abuse, had a reputation for honesty. For admissible 404 opinions, I believe Officer Fricky has opined that there is a willingness to follow the law and something about being a good police officer. The state is asking the court to limit her opinion to those only which are admissible. The others seem obviously outside the scope of the court's prior ruling.
Well, Officer Fricky works for Brooklyn Park now and was an officer for Brooklyn Center for almost 15 years and worked with Officer Potter. Officer Potter was her mentor and partner in many shifts, and the witness summary discussed what it was like to work with her. What was she like as a police officer? And so I certainly will respect your ruling on law-abidingness and peacefulness. I'm not going beyond that, but she can describe what it was like to work with her. In fact, she was asked to stay with her after the incident because she had worked with her, and she was specifically asked to stay with her for the duration. So that's the context for that.
Okay. Could I get the witness summary for
I
her?
think they gave you the summary.
All right. I don't know if I still have it. Could I get another copy?
Sure, Your Honor, we can probably get that back to you.
Okay. All right.
I do appreciate Mr. Eng's comments, and I guess I wasn't expecting bad faith, but I certainly thought it was worth making a record of this. General background information that would form the foundation for her to elicit that opinion is certainly sufficient. Where I think that there can become issues is when someone preparing to elicit a 404A1 opinion goes extremely specific in describing the background, which essentially accomplishes the prohibited goal of talking about specific instances. So I'm going to take Mr. Eng at his word, and we'll just act accordingly. Lastly, Your Honor, obviously Ms. Potter's under no obligation to testify, but there were some of these individuals who opined with regard to truthfulness. Truthfulness is obviously not a 404 opinion. That would only come into pertinence after she testifies, after her credibility is attacked, and it would come in under 608A. That's all with regard to 404 issues, I believe. Pardon me.
There was one other issue that was not a 404 issue, which was character witnesses that we'd like to address, Your Honor.
Okay, please go to the podium. First of all, let me just say that specific instances of good conduct is not going to be admissible under 404, okay? Character traits only.
I appreciate that, Your Honor. I think just to dovetail off that, obviously, Commander Flesland was asked some questions about whether Ms. Potter was a good cop, and he said she was a good cop and a good person. We objected. That was on the record at sidebar, but whether someone is a good person is also improper character evidence, so we would continue to object to that.
Yes.
Stemming from that as well, when it came to Commander Flesland's testimony, raises another issue. Obviously, the state had briefed a motion with respect to potential bias, union membership. We argued that motion to the court. That was yesterday, I believe. After we argued that motion to the court, however, was when Commander Flesland was called. Commander Flesland was called, and then on cross-examination, defense counsel elicited testimony directly from him about the scope of union work that Ms. Potter did, her role as a union steward. I had pulled some of the testimony, but the questions were essentially about negotiating a contract, but then there was follow-up questioning about additional duties beyond negotiating contracts. Mr. Gray asked what else would that be. That included representing officers and detectives in the bargaining unit, helping negotiate if they've been wronged, and potentially go down the grievance route for something like that. The union stewards help them navigate that process. It's our position, given the testimony elicited by defense counsel in this case, that they have opened the door clearly to any potential cross-examination on our behalf of their witnesses when it comes to bias, union membership, and union affiliation.
Would the defense like to respond?
Well, Your Honor, I'm not quite certain being a member of a union shows bias. I didn't expect the answer that I got when I asked Commodore the question about the union. I believe that our client, just negotiated contracts. She didn't do much else. She will testify to that. I have a hard time believing that in this day and age, the state of Minnesota is accusing a union member of bias because she belongs to a union. It's hard to believe. But if they want to attack our client, because she's a union member, it seems way out there. It doesn't seem relevant at all. I mean, how many on the jury, how many people in our nation are union members? I think the public defenders are, county attorneys are. All kinds of people are union members. What does that mean? I mean, so you're the union steward. Would that mean you're going to take the stand and lie? I don't think so. And I think that's why it's improper to to impeach somebody by, oh, you're a member of the union. Oh, she's the head of the union. That's not proper impeachment nowadays. Thank you.
Okay, I think the state's point was that with respect to defense witnesses, they want to be able to cross-examine and show that defense witnesses may be biased because of Officer Potter's former position as union president, I think it was.
That's correct, Your Honor. The state is in no way criticizing anybody for being a member or not being a member of a union. The issue goes directly to the heart of whether or not bias exists, and that relationship between each of these witnesses, each of these officers who may have used or relied upon the defendant to help them through a grievance process, who looked up to her as president of the union, who went to her for advice, who, you know, she may have shepherded them through this process of addressing grievances, and she was essentially their advocate. That goes to bias between bias of each of the witnesses who testifies, not only to her character, but also whatever testimony is elicited through the defense direct. So not only is it bias with respect to anything that may come out if the defendant should choose to testify, but each witness who testifies about a relationship with Ms. Potter, there's a connection there that is deep-rooted, deep-seated. There is an established relationship, and clearly it's probative of bias for us to be able to ask questions about that relationship.
Well, it would only be probative of bias if Officer Potter actually represented any of these witnesses and had a close relationship with them because of her former position.
And Your Honor, just getting brief highlights of the testimony from Commander Flesland. His testimony was that they're there to represent the officers and detectives or whoever is in that bargaining unit. They can help that officer negotiate if they've been wronged and potentially go down the grievance route for something like that. The union stewards can help them navigate that process. So that testimony was elicited by the defense. That shows that relationship and the assistance that Ms. Potter would have given them.
Okay. Anything further on that?
No. But one of my, one of the three character witnesses maybe themselves, the lay witness. So I've got it down to 3.
Okay. All right.
Judge, she wasn't the union member for most of these folks that are going to be testifying. She wasn't the union advocate in the first place.
Okay, you can bring that out on cross. All right.
I mean, I don't.
Okay. Mr. Frank or Mr. Larson? Okay.
You've already argued something in chambers here, and I was just going to ask whether the court has made a ruling on Exhibit 1002.
What's 1002?
To refresh the court's recollection.
Yeah, please.
I believe it was yesterday, defense counsel shared with us a short video from a time frame
yes.
when Officer Potter and Officer Fricky were at the Brooklyn Center Police Department. Need I say more?
Yeah, I remember. I did review that video, and I'm not going to allow it. She can testify as to what her interaction with Officer Potter was, and I'm doing that because it really isn't relevant to the issues in this case. So, but I'm not going to restrict her from testifying about it. Okay. All right. Mr. Frank?
Your Honor, I think this is the last thing we have, and we just thought we should raise this with the court now so it doesn't come up tomorrow as we're trying to move through the testimony. And, Your Honor, we, I think, have provided the expert reports to the court for your review. I believe I heard Mr. Eng in opening say that Mr. Imes will testify, their use of force expert, about deadly force. And if I misheard him, I apologize, but because I'm not certain about it, I wanted to raise it. Now, there is nothing in Mr. Imes' report about the use of deadly force, and so we would object. The disclosures were required months ago. Nothing in that report about the use of deadly force, as our witness testified about. So we believe that that is not proper testimony from him. We just wanted to raise that with the court now so the court's aware of it.
Okay, Mr. Eng?
it's permissible for the expert witness to review evidence as it comes into the case. I've asked him to review the testimony of, in particular, Sergeant Johnson and Officer Lucky. I've also asked him to review the testimony of Mr. Stoughton today, particularly as to the reasonableness of the force and his analysis of the dangers inherent in the setting, and to agree or disagree with Mr. Stoughton. So this is new evidence that was not available. The testimony certainly wasn't available. I've asked him to review that for the purposes of either agreeing or disagreeing, and that's what an expert does. So that's what I'm going to ask him to do.
Okay. Why wasn't that his opinions disclosed earlier?
Well, the initial opinion was that the taser was appropriate to be used, and then as the evidence developed, we've asked him to keep an open mind about it, and our assumption is that there would be new evidence at the trial because, first of all, we don't know exactly what they're going to say. And the Johnson testimony was extremely significant, and he didn't have that. And, one of the cross-examinations of Stoughton was he didn't have the Johnson testimony in his original report either. So the newness of the evidence is what we're going to ask him to look at.
Okay.
Okay.
But of course, Your Honor, is this microphone going to be okay, or do you want me
I think the court reporter can hear. Yeah.
We have absolutely nothing from Mr. Irons about the use of deadly force. So to say this is new evidence means he's creating a new opinion that wasn't disclosed as it was required to be. The Irons report is, I'm sorry, I don't have it right here in front of me, 4 or 5 pages long. It's very scant on its support for its opinion anyway, but now to add a completely separate opinion about the use of deadly force is just, we just had no notice about it as the court ordered. So we maintain our objection to any testimony about that.
Well, I'm duty bound to talk to my expert. I plan to do that in about a half hour if I can get out of here. And he's downtown right now. And I will disclose the nature of the conversation that I have with him immediately. But I'm a duty bound to ask him what his analysis is of the testimony that he's seen. So, that's my obligation as a lawyer for Officer Potter to see what he says now, particularly about the Stoughton testimony and the analysis of it. He's certainly free to disagree with another expert's testimony. And they know that.
Okay.
It's a discovery violation, Your Honor.
Let me think about that one, okay? And I'll let you know immediately. In the meantime, you'll make an immediate disclosure as to his additional opinions on deadly force. Okay, so I'll take that under advisement. And anything else before we...
Well, if I could go on to a private matter.
Okay.
Good Lord, now they're stretching out, ending it for the day. They want it all to take forever. Well, when they wrap this up, we're going to do the Pledge of Allegiance. Right now is a good time to hit that subscribe button or follow on whichever platform you're currently watching right now in order to be connected. We try to go live every single day if possible. And by joining my account, you're helping my channel grow on that platform and potentially bring in new viewers to see what's happening around us. Hydrodynamic, don't you get brazen with me. I wish we had Judge Pickles. I mean, Judge Phone Sex Hotline is all right, but not like Judge Pickles. He was getting it.
Okay, is there anything else, Counsel? Okay, council, have a good night, okay? And drive safely tomorrow morning. I think it's going to be really icy.
All right, Pledge of Allegiance time. All right, please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, everyone, that is it. We are wrapping this up for the day. I don't think there's anything going on. I will take a gander, but I'm probably going to spend the night trying to figure out how to get my Instagram back from some crackhead that stole it. Stupid. What a stupid thing. Anyways, we will be covering the trial again tomorrow, and I hope to see all of you there. Hope you guys have a good night. Appreciate all of you for being here. Big shout out to everyone that made donations, joined the membership program, or purchased any merch. I really appreciate you guys, and I wouldn't be able to do this without you. So thank you so much for being here. Hopefully you guys have all subscribed and you've all joined the Discord to stay up to date with what's going on and have all these hooligans to talk to 24/7. I will see you guys on the next live. Until then, stand tall, shine bright, and that's a wrap.